Hello! In the following, I would like to give you an overview over the amendment practice under the PCT. I would first like to discuss what amendments actually are. Then I would like to highlight the three possible amendment types that exist under the PCT. And I would like to discuss some of the particular issues concerning each and every type of amendment that an applicant can make. And of course, I would also like to refer to how to actually submit these amendments in practice. So what are amendments? Well, amendments are essentially changes, modifications made to the main part of the international application, so the claims, the description, the drawings, and they're made after the time of filing. And it's important to differentiate amendments from other submissions that you might make during the international phase. For instance, formality corrections. Formality corrections try to address certain formality issues, informal drawings, for instances, which were submitted, and you submit formal drawings, and thereby you correct a formal defect in your PCT application. That's not an amendment. Also, another issue is rectification of obvious mistakes. What you're doing here under Rule 91 would be to correct something which from the very beginning was wrong, and it was obvious that it was wrong, and so at the end it will be treated as if it had been right from the very beginning. So amendments apply as of the time when you submit them. Rectifications go back in time to the original submission of the document that we're talking about. Now, it's clear that the amendments, since they concern the main part of the international application, are substantive by nature. And there's one important limitation, at least for those amendments which you can file during the international phase of the PCT procedure. And that is, amendments may never go beyond the original disclosure, or in other words, they cannot add additional subject matter that wasn't already disclosed at the time of filing. Now, later on in the national phase, national law might be a bit more lenient on the issue. And the national law of some countries at least would allow also the addition of new subject matter. But under the PCT, there's a clear and strict limitation. Amendments cannot go beyond the original disclosure. So what are the three possible types of amendments that an applicant can make? Well, first of all, there's Article 19. That's amendments of the claims. There's Article 34 during the Chapter 2 procedure. And as a last possibility, amendments can be made under Article 28 and 41 at the time of national phase entry or once you are in the national phase. So let's talk about each and one of those types in turn. So let's start with Article 19 amendments. Under Article 19, you have one opportunity to amend the claims, and it's the claims only, after receipt of the international search report. Such amendments may be accompanied by a statement. In that statement, the applicant would clarify substantively what effect his amendments he thinks would have on the claimed invention. And obviously, he would also try to show that through those amendments, he's able to overcome some of the objections raised by the examiner in the search report. Time limit to submit Article 19 amendments is generally within 2 months from the date of transmittal of the international search report. There are a few cases where you actually have a little bit of a longer time limit, and that would be in a case where your search report is established really early on, and there completion of technical preparation would be the longer time limit if that expires, so to speak, after the 2 months from the date of transmission of the search report. But again, it's really only in cases where you receive your search report at a very early stage. You need to file Article 19 amendments directly with the International Bureau. We will actually not be able to do a check on whether you have added additional subject matter, whether your disclosure or whether your amendments go beyond the original disclosure, as I said earlier. Why? Because we are not actually staffed with substantive examiners. We have a lot of formality examiners, so we'll check the formality aspects of your amendments, but we cannot really check the substance. However, rest assured that this question is not going to be forgotten. If you keep relying on your Article 19 amendments that say in the Chapter 2 procedure, the IPA will look at that very question. And if you take those Article 19 amendments which you made into the national phase, the national offices are also entitled to look at exactly that question: did you add additional subject matter when you filed your Article 19 amendments? The Article 19 amendments, and that's a bit special in comparison to some of the other amendments, they are published with your international application, and at the same time what we publish is the claims as originally filed and the claims as amended. So the second type of amendments that an applicant can make is under Article 34 of the PCT. Now this is really only available to those applicants that have chosen to file a demand for international preliminary examination. Without that, you cannot rely on Article 34. What's nice about Article 34, it allows you to amend all parts of your international application. That's the description, including maybe also a sequence listing submitted, claims, and the drawings. You need to file those amendments directly with the competent international preliminary examining authority, and we would recommend to always file them together with the demand. The rules actually say that you can submit them later, but an examiner at the IPA does not need to take these amendments into account if he already started to draw up the examination report. And since an applicant doesn't really know when internally the IPA will do that, he can really only rely on filing it together with the demand, or at the latest before the time limit to file a demand under Rule 54 bis expires. And that time limit is 3 months from the date of mailing of the search report and the written opinion of the ISA, or 22 months from the priority date, whichever expires later. Again, as I said earlier, also Article 34 amendments may never go beyond the original disclosure. If they do, in this case, you will have substantive examiners at the IPA that can look at this question. If they realize it goes beyond the original disclosure, they will not use them as a basis for the final report that they will be issuing, the IPRP Chapter 2, the International Preliminary Report on Patentability, but they will go back to the application in the state that it was in before filing those amendments. So the last type of amendments is what we refer to as national phase amendments. And here really the PCT only stipulates sort of a minimum guarantee for applicants. It allows and guarantees to applicants that they are entitled to make such amendments at the time when they enter national phase or subsequently, and they are entitled to change again and amend all parts of the international application. What the PCT also stipulates is a minimum time limit for applicants to do that, and it says that national offices must give applicants at least 1 month from the date of when he has fulfilled all the requirements to enter national phase. So if he enters national phase early, it could be 1 month from that time limit. If he waits until 30 or 31 months, whatever the applicable time limit is, it's from that date that he has 1 month to file his amendments. But of course, national law is usually much more liberal than just stipulating a 1 month time limit. It usually provides for longer time limits, and of course that would then apply in a particular case. As a matter of fact, really that is all the PCT regulates. How those amendments are to be made, what documents need to be furnished, etc. This is all governed by the national law and could of course differ from one designated to the other designated office. Of course, the beauty of national phase amendments is that you can amend your application very specifically for the purposes of each and every designated office. Maybe you know that an examiner at a particular national office likes the claims to be drafted in a certain way, so you can amend your claims accordingly. Another reason why a lot of applicants amend applications when they enter national phase is to avoid claims fees, which are often charged by national offices. And most offices would apply their claims fee based on the application as amended when the applicant amends it when he enters the national phase. Do note, however, there are a few offices which do not follow that practice. They will actually charge a claims fee based on the application as filed or as published. Even if you amend, if you reduce your claims from 50 to 10, you might still not, before those offices, be able to avoid a higher claims fee. Now, of course, one of the questions that an applicant needs to consider in all of this, is it better to do these amendments during the international phase, or do I wait until national phase entry? And here the answer is, it really depends. Some of the consideration which you might like to make is, do you, for whatever reason, want your amendments to be published? Now, if it concerns the claims under Article 19, you would have an opportunity to get them published. Are you anyway interested in filing a Chapter 2 demand because you want to work on your application and get a more positive result than what you have obtained from the International Searching Authority? Well, if you do that anyway, of course, it makes a lot of sense to then file Article 34 amendments. Filing Article 34 amendments or Article 19 amendments, of course, also has the advantage that you as the applicant or agent, you're really in charge of what you're amending, and it has effect once and for all the designated and elected offices. So you don't have to do it individually before each office, you do it at one time and it has effect in all offices. Of course, national phase amendments also have the advantage, as I said earlier, that you don't have to do it once and it applies everywhere, but you can do it individually and fine-tune your amendments to the requirements of each and every national office. Do maybe also keep in mind that both doing amendments during the international phase and again during the national phase is of course also an option and might be interesting in particular cases. Now, if you decide to file amendments, and now I'm talking mainly about the amendments under Article 19 and Article 34, what do you actually need to submit? Now, one very important thing to realize is if you amend your claims, you have to file always a complete set of your claims. Not just individual pages, but you need to submit a complete set of the claims. That's different if you amend the description or the drawings under Article 34. There, an individual replacement page where you present your amendments would be sufficient. But that does not apply to the claims. For the claims, as I said, you need always a complete set of claims. It's also very important that you always have an accompanying letter that you submit together with your amendments, signed of course by someone entitled to represent the applicants. And in that accompanying letter you need to do two things. First of all, explain what amendments you've made. I deleted claim number 2, I added claim number 10. That's one aspect. The other aspect that's also required is you need to, in that accompanying letter, indicate the basis for the amendments. Now, this is really a tool to help the examiner who's obliged to look at the question, did the applicant go beyond the original disclosure, to more easily find the part in the description, for instance, where you already talk about certain features which you are now using for your amendments, and that way he can more easily come to a determination whether you added additional subject matter or not. It's really important that you indicate the basis of these amendments. If you don't do it when you file your Article 19 amendments in your accompanying letter, we will invite you to still do so. If you don't come forward with such an accompanying letter, we will still accept your Article 19 amendments. But if those Article 19 amendments then go to the IPA, they could challenge again that you did not indicate the basis of the amendment. If you file Article 34 amendments, it's one of the requirements that the IPA will apply. If they don't find an accompanying letter indicating the basis of the amendment, they can ignore those amendments. They're entitled to not take them into account. Do also note, just from a formality perspective, if you cancel certain claims, you don't need to necessarily renumber the remaining claims in the application. You can do it, but you don't have to do it, and that's helpful in a case where there's lots of cross-references in the claims, that you don't have to be very careful when you submit those amendments and by verifying these cross-references again. So in this presentation, I explained to you the 3 points in time during the PCT procedure when you can actually amend your international application. And I try to explain some of the benefits of the various possibilities. You also learned about the formality aspects that you need to respect when you submit your amendments, and I touched upon the question of whether it makes sense to amend your application during the international phase or whether you rather choose to file amendments once you have entered the national phase before the designated or elected offices.